CBI, these were the direction of the Rouse Avenue Court. But now today at 10:30 a.m., senior advocate Abhishek Manu Singhvi had knocked the doors of the Supreme Court, where he went and said that on the side of Mr. Sisodia, that the entire manner of investigation needs to be looked with fresh eyes. The entire case needs to be looked with fresh eyes, Ankit, and that is what is going to happen. They want the Lieutenant Governor to be questioned and not be brushed aside, because he's one of the people who approved the excise policy, and the tweaks that are being talked about, which were allegedly made by Mr. Sisodia, Ankit, that are under the question. But the side of the council has been asserting that if the tweaks were rather apprehensive, why was the approval given, Ankit? So in next couple of minutes, we'll see the hearing beginning.
Absolutely. We still have Madhurima Kapil Sankhla with us, Supreme Court advocate. Now, Kapil, one of the things that you didn't really get into was this whole issue of whether or not someone is cooperating or not, because there was a bit of a deliberation about this in the Rouse Avenue Court yesterday. What are the finer points to you? The CBI says he's not cooperating. Manish Sisodia's counsel says just because he doesn't say what you want them to say doesn't mean he's not cooperating. What are the points that need to be delineated here?
So let me put it like this, very honestly, as a defense lawyer who's been doing this for 25 years, I do have a problem when any prosecuting agency comes and says that the accused is not cooperating. And the reason is this: as far as what the prosecution thinks or investigating agency thinks, cooperation would mean that you give answers which can incriminate you. And we know that it is our fundamental right in this country not to incriminate ourselves, not to answer questions that will incriminate us. And we cannot be made a witness against us. So as far as the statement of cooperation is concerned, I do hope and I do wish that the Honorable Supreme Court visits this and puts up certain guidelines. In my view, a cooperation would be if you're trying to derail investigation. I mean, so if you are saying that you have done something, or there is certain a bank account or certain files, and you say that it is at point A and it is discovered that it is point B, so that would mean that you are trying to derail investigation. I would understand that under the circumstances, if you volunteered certain information and that information turns out to be false on the face of it, which basically means that you are making the prosecution go helter-skelter, not come to the real issue, then if you say that you're not cooperating, it's right. But if you say that I have asked a question and that question can incriminate the accused and the accused has refused to answer the same, then I think that CBI or prosecution is shirking from its duty and what it is set up to do, the investigating agency. In this particular case, I do understand that this is again the argument of CBI that he is not cooperating with investigation. So if the nature of the question and the trial court was absolutely right in its assertion that it has to be recorded under CCTV camera recording and that recording has to be preserved, so therefore the courts would have the benefit of looking into the kind of questioning that the CBI is conducting. We do know that the Honorable Supreme Court as well as various high courts in various judgments have said that during investigation, the counsel for the accused cannot be present at hearing this, which means that the accused counsel can be present with the permission of the court, but he cannot participate in the investigation and he cannot be at hearing this. So which means that there are eyes of the court, so to say, or the eyes of law which are watching the nature of investigation. In this case, it is even being recorded. So therefore, the Honorable Court would be seized of the kind of questioning that is happening, and therefore the proof of pudding is that the court will look into the kind of questioning. If the kind of questioning is such that they are designed to incriminate the accused, which would mean that the CBI is basically putting the onus on the accused to prove itself, that would be incorrect, that would be wrong. So in that way, as far as the defense lawyer or a student of law is concerned, I would be completely in favor of the fact that the Honorable Supreme Court comes up with certain guidelines and say that, listen, you cannot, this is what the law is, you cannot incriminate, make a person incriminate himself and be a witness against himself. But if the nature of questioning is such that you're asking where are the files or where is the mobile phone, please hand it over because this would be under your exclusive custody, and the person says, I don't know, it is found out that he knows or he's hidden it or destroyed it, under those circumstances, the investigating agency would be right within its powers to say that the accused is not cooperating with the investigation, is not helping with the investigation, is in fact trying to derail the investigation. So these are two important points. And unfortunately, the Honorable Supreme Court or no other court till date has actually come up with concrete guidelines as to what really would mean by cooperation of the accused. So therefore, what has to be seen, and probably in this case itself, the Honorable Supreme Court may lay down certain guidelines as to what is cooperation, because this is one of those exceptional cases where the trial court has said that the nature of the investigation and the investigation that is being taken place and the nature of examination, interrogation that is taking place, that has to be recorded and kept for posterity for the courts to look into.
Right.
So let us wait and watch. Let us see what happens. This might be one of those